From a distance, it's obvious. The chorus of mockers doing Jeremy Hales's bidding isn't helping his lawsuit, they're poisoning it. Courts look at conduct, and when supporters harass, dox, or intimidate, that behavior can boomerang as evidence of bad faith, abusive process, and even witness intimidation. Start with the law. In Wisconsin, harassment is illegal, Wisconsin Stat. Perf 947.013 prohibits a course of conduct that harasses or intimidates. Stalking is worse, Wisdom Stat Paragraph 940.32 covers repeated conduct that causes fear. Across state lines, the federal stalking statute 18 U.S.C. Paragraph 2261A forbids using the internet or interstate communications to harass or intimidate with intent to cause substantial emotional distress. None of that looks like advocacy, it looks like liability. Civilly, the same antics set the table for intentional infliction of emotional distress. Conduct so extreme and outrageous that it's intolerable, done intentionally or recklessly, causing severe distress. See Alstein vs. Gale, 21 Wis 2D 349. If the pylon targets someone's livelihood, the conduct strays into tortious interference with business relations. Intentional and unjustified interference causing economic harm. And when the mob republishes defamatory claims, the republisher can be liable as if they authored it. Restatement 2nd of Torts, Paragraph 578. Wisconsin Defamation Standards from Torgerson vs. Journal Sentinel, 210 Bubbies Wis 2D 524, require falsity and fault, but the megaphone effect doesn't grant immunity. In court, this swarm hurts the plaintiff's credibility. When a plaintiff benefits from a campaign of pressure or fear, judges can read that as unclean hands and harassment inconsistent with good faith litigation. If supporters try to chill testimony or scare a defendant into waiving rights, it starts to smell like witness tampering territory. 18 U.S.C. Paragraph 1512 bars intimidation, threats, or corrupt persuasion related to a federal case. No lawyer wants their client anywhere near that line. Abusive process doesn't require winning or losing. It's about misuse of legal procedures for an ulterior purpose. See Strid vs. Converse 111 Wis 2D 418. When online foot soldiers turn a lawsuit into a cudgel, mocking, doxing, and pressuring, that pattern reads like ulterior purpose, not a quest for justice. Employers and peers take note. Some of these keyboard warriors present themselves as teachers, respected community figures, even men and women of God. Yet behind sock puppet handles and Muppet avatars, the conduct is childish, petty, and frankly evil. If their school boards, congregations, or professional associations saw the receipts, would they call it ministry, mentorship, or just misconduct? Courts also recognize that online mobs can contaminate the forum. Coordinated harassment risks sanctions, protective orders, and evidentiary consequences. A plaintiff can't claim clean hands while a cheering section tries to terrify defendants into submission. Judges notice patterns, timestamps, screenshots, and coordinated dog piles aren't passion, they're exhibits. Make no mistake, every taunt, every pile-on post, every gotcha republish of a false claim helps the defense argue harassment, emotional distress, interference, and bad faith. It undermines the plaintiff's narrative and invites judicial scrutiny where he least wants it. And for the record, the I watch so you don't have to account is extremely heinous and diabolical, an accelerant, not a shield. In the end, this isn't advocacy. It's self-sabotage dressed up as fandom.